Good afternoon, sir. Shall I start?
Yes, you can start now. No problem.
You can start.
Yes, sir. Yes, sir. A very good afternoon to one and all. On behalf of School of Allied Health Sciences, Vinayaka Missions Research Foundation, deemed to be university, and design filing organized by Institution Innovation Cell, SAHS, in association with Rajiv Gandhi National Institute of Intellectual Property Management, RGNIIPM, Government of India, Nagpur, under National Intellectual Property Awareness Mission. RGNIIPM is a central government institute under the Ministry of Commerce and Industry, is engaged in conducting training awareness programs related to IPR, that is, patents, designs, trademarks, geographical indications, and copyrights. RGNIIPM has established at Nagpur as a national center of excellence for training, management, research, education in the field of IPR. It's our pleasure to organize this workshop in association with RGNIIPM. Now, I would like to
You're muted, ma.
So, can you hear me, sir?
Yeah. Can I start? Can I proceed?
Yes, sir. Yes, sir. Yes, sir.
Wishing you all a very fabulous afternoon and warm welcome to one and all for this online workshop on intellectual property rights, patents, and design filing organized by IIC and ESL of School of Allied Sciences in association with Rajiv Gandhi National Institute of Intellectual Property Management, Government of India, Nagpur. My hearty welcome and thanks to our eminent guest speaker, Dr. Bharath N Suyawanshi, Assistant Controller of Patents and Designs, for having agreed to share his valuable time and knowledge with us. We have been taking constant efforts and helping in upgradation of knowledge and skills of our faculty and students in the area of innovation and entrepreneurship. In the modern era, intellectual property rights play a significant role on trade of every nation. In this digitized world, there stands a high risk of creative ideas getting stolen without the consent of the author. The need for strong IP laws gives an overall contribution in the economy of respective state. IPR is one of the sources of security for intangible properties which are still open to the public and which can be quickly replicated by anyone. The session for today has been planned since we understand the importance of IPR as it provides incentives to the individuals for new creations, due recognition to creators and inventors, and also aids in the economic growth and advancement in technology sector. We are expecting enlightenment appreciation to Ms. Tamil Sudat for organizing this webinar. I once again welcome you all and wishing you all happy learning. Have a good day. Thank you. Over to Priya.
Thank you, sir. I feel very privileged to introduce the guest speaker of this workshop, Dr. Bharath N Suyawanshi. Dr. Bharath N Suyawanshi is working for more than 18 years in Central Government Office under the Patent Office, Ministry of Commerce and Industry, and presently working as Assistant Controller of Patents and Design. He has done PhD on topic bioefficacy and phytochemical studies on medicinal plants of Kinwat and Mahar Forest of Nanded district from Swami Raman and Teerth Marathwada University, Nanded, Maharashtra. He has done MPhil on topic plasmid profile of proteolytic lactic acid bacteria from Gulbarga University, Karnataka. Postgraduate in biotechnology from Gulbarga University, Karnataka. He has published various national and international papers. He has delivered Sir, am I audible, sir?
Yeah, no.
He has delivered many lectures on IPR in various parts of the country. He was deputed for training in Tokyo, Japan on examination and IPR issues. He has given landmark decision by rejecting Pfizer patent application for arthritis drug which was filed in India in 2015. I request our guest speaker to take over the session. Please, sir.
Thank you, ma'am. Thank you so much. Good afternoon to all. I welcome you all for the IPR session on behalf of Rajiv Gandhi, National Institute of Intellectual Property Management. As everyone is knowing about my slides. Are you able to see my slides? Anyone? Hello?
No, sir, it is not visible, sir.
Okay, just a minute. Now it's okay? Are you able to see my slides?
Yes, sir. Yes, sir. Yes, sir.
Yes.
Slides are moving. Just check it out. Slides are moving.
Yes, sir. Yes, sir.
Okay, thank you so much. Yeah, I'll start firstly with the introduction of myself, where I'm working. I work under the Ministry of Commerce and Industry. Now it is called as Rajiv Gandhi National Institute of Intellectual Property Management, located at Nagpur. We are having trademark offices in addition to 4. One is at Ahmedabad and geographical indication office at Chennai. These are the pictorial view of our offices: Mumbai, Delhi, Chennai, and Kolkata. If you want to file physically, you are supposed to go to the particular office where you are having your jurisdiction. This is our training center wherein we give physical trainings, that is classroom trainings, to all IP officers, professionals, teachers, students, lawyers, many scientists, doctors, any kind of field, even foreigners, those who want to know about Indian patent law. But because of COVID, we are conducting all the programs online. This is our website. If you visit on www.ipindia.gov, you can get all details about the different kind of intellectual property rights. This is an awareness program, so we cannot go in detail. Therefore, we are conducting some programs online in detail. So we are keeping update on our social media accounts like Facebook and Twitter, as well as our website. So if you want to know more about that, you can join with us. Let us see what is intellectual property. By seeing these slides, you might have thinking something which is product of mind is called intellectual property. Yes. When it arises during discussion in the classroom or any problems in and around us or in public, if you are thinking on any problem, if you find out solution, that is human finds solution because he thinks on that. So intellectual property means something which arises from human intellect or it's a product of human creation. For example, if design, he is creating. If trademark, he is creating. If he is doing patent, then he is thinking and he is carrying out the research work, so he is getting the patent for the technology. Here I want to quote you an example as it's to prove that it's a human creation. In December 2019, we heard about the coronavirus. At that time, we are not having any treatment method nor vaccine for that. The scientists of biotechnology, pharma, microbiology all over the world started doing the research on the coronavirus. They studied the coronavirus of morphology and genetic constitution of that. Ultimately, we got the solution in the middle of 2020, that is Covaxin, Covishield, Sputnik. What is this? This is a product of human mind. It arises from human creation when they thought on particular problem. Therefore, it's an intellectual property. Another example, for example, earlier we are having X-ray machine. But in X-ray machine, what we can get only what the exact where the infection is there. But improved in that technology, we got CT scan machine, wherein we get more accurate result over that. So what is this? This again product of human mind. It's an creation from a human mind. So therefore, it's called an intellectual property. For example, another I will take you for now we are having renewable source of energy because one or other day petrol, diesel may exist from this earth. So scientists are thinking to produce biodiesel. The process of production of biodiesel, if it is new, then it's an invention which is originated from the human mind because he is thinking that one or other day non-renewable resources will exist. Therefore, it will be more inventive they want to do, more in new technology they want to, so they are producing biodiesels. One of the flight from Dehradun to Delhi has a flight on using the biodiesel. So something new which if you are giving the vehicles which on electrical energy or vehicle which run on hydrogen fuel, these are called intellectual property. Let us see what is the background of intellectual property. Property means our mind goes to the tangible form of property. That's I'm having car, gold, flat, so I'm rich enough. But there is another kind of intellectual property which is called intangible form of property, which includes industrial property in that we are having copyright and patents, designs, trademark, and GI. So properties. Let us see what is the definition of intellectual property. Intangible creations of whom? Human intellect, means it's originating from the human mind and it has a commercial value asset like any other form of property. For example, as now Omicron came, somebody gives a solution for that Omicron, then that's one of the property. If you sell to another company, it's an asset because you are getting royalty on that. So though whoever creates a vaccine for that, for example, Ranbaxy company is producing vaccine. So he can license to Bharat Biotech of Hyderabad or Reddy's of Hyderabad or Biocon of Bangalore for commercialization. In that, it returns get the royalty for that. There is solution asset like other form of property. There are different intellectual exclusive right. Patent is an territorial right. If you are filing your patent application for your technology in India, it's valid only in the territory of India, not worldwide. If you want to establish your right in other countries like USA, Japan, China, Germany, you are supposed to file your application by means of PCT, that is called Patent Cooperation Treaty, or by means of conventional application as per section 135 of the Patent Act. Patent is also called as licensable right. If you are getting patent on any technology, you can license to anyone whom you want by taking royalty or by selling in the market. Let us see what is patent then. Exclusive monopoly privilege are right granted by the government to the patentee for 20 years from the date of filing, priority for commercial gain in consideration of the full disclosure of his invention as a territorial right not world. Means this is a right given by the government for 20 years from the date of filing. Only in the territory of India for what? Commercial gain, not to take the patent and keep in the file record to get a promotion. It has to help someone else. Therefore, it's we are fulfilling the requirement of IP, that is intellectual property. Still, many are in dilemma or confusion. What is discovery and invention? They say, I invented metal. They say, I invented microorganisms. So before that, we should know what is discovery and invention. Finding or exploring something which is already existed. Discovery as such has no technical effect. For example, we know the periodic table. We have studied since 11th and 12th what is periodic table. Now maybe it's 9th only for CBSE and all. So somebody is isolating new metal or element from the earth or environmental conditions from anywhere else that we know the metal are present. So as such, isolation is a discovery. But the method which you are employing to isolate, for example, the process of isolation of metal or element, if you are using new method steps, it may be new. You can file the patent for that, but not the metal as such. It's a discovery. Again, I'll quote another example. For example, I am isolating microorganism from jute industry or effluent of cement industry. We know some microbes are present in the region that may be alkalophilic, acidophilic, or any whatever kind may be, but we know. But I'm employing the method of that media for that pH what I have to maintain. Then I'm isolating. The process of isolation of that microorganism may be new. You can file for the patent application, but not the microorganism as such what you are isolating from jute industry effluent or cement industry, because we are just doing discovery. But genetically, if you are modifying that microorganisms by using recombinant DNA technology, then you can file for the patent application because it's an human intervention, something you are doing with the recombinant DNA technology with that microorganisms. For example, oil-eating bacteria. So we should know whether we are doing inventions or discovery. If you are doing the invention, you can go for the patent filing. What is invention then? New product or process which is useful, again novel, non-obvious, and not public knowledge before the filing date, then where subject matter is said to be an invention. Even for the paper publication, what we do, whether my work, whether technology what I did, or the research paper what I have written, is it in public domain, any other journals or not? If not, then only we go for the publication. Same way, if you want to get an say your technology as invention, you should fulfill these requirements. Simple example is sharpening. First time C.A. Boucher has invented, it got patent for that. Same way in the genealogy we studied, the electric bulb got patent by the Thomas Alva Edison. Alexander Graham for telephone. Lot of things we studied in the genealogy. So first time whoever develops the technology, they will get patent for that. This is a telephone which Alexander Graham has got patent because first time invented. What are the true drawbacks of this? One, if I want to dial my friend or somebody else, 10 times I have to dial. You might have seen in the old movies. One disadvantage. Another is I cannot change from my cabin to somebody else's cabin because it is connected at a particular point with the connection. Then only I can talk. Therefore, the scientists of electronic and telecommunication, to overcome this objection, this problem, they came with a button phone. But again, in this phone also, we can directly dial, one problem solved. But another disadvantage is that I cannot change from my cabin to another because it also connected to a particular point. To overcome this, again, scientists of electronic and telecommunications did the research. They got with a cordless phone, which are very long, which you can take in nearby area like hall, kitchen, drawing room. But we cannot take in the meeting, nor with us, nor in the jail. Therefore, we got the mobile phones in the year 2000, in and around that. This is called improvement in the technology, what is existed in the year 1876. So all improvements got patent, like Nokia, Samsung, Reliance, Vivo. What is this? Because improvement in technology, you are solving some problem. So always do invention. Don't think that something you are doing new things. If you're solving any problems of in and around you in your own subject, you can get patent for that. X-ray machine was there. Now we got CT scans. So some problem you are solving, you are giving new technology, so you are getting patent for that. Fridge. Well, earlier we had different fridge, now we are having different fridge. That is improvement in the technology. Something if you are doing improvement also, you can file the patent application. Earlier I quoted very old examples, which is in 1994 example is on Bluetooth. Before this, we are not having any tool to transfer the data. Therefore, Geoff Hudson has invented in the 1994. Now we are saying, I am having Bluetooth, I'll transfer the data with my mobile. It's a technology. Most common mistakes by the inventors. Most of the people are doing good things, especially teaching faculties, but they run for the publication, the international journals and all. But first file the patent application, then go for the publication. Or knowingly, unknowingly, if you are publishing in or disclosing some conferences, then from the date of that disclosure, within 1 year, you can file the patent application. If you are having technology good, if you are using in the Public, please maintain the secrecy, otherwise somebody will copy and they'll file before you in the patent application. If you are carrying the research and you are not sure that your invention is having value, then wait till whole lab work complete. When complete your lab work or prototype, then you think it is having value or not. If it is having value, then only you can go for the publications. Let us see another kind of intellectual property called designs. Design means shape, configuration, pattern, or ornament or composition of lines or color combination thereof. Applied to any article, 2D or 3D or in both the forms. For example, Bajaj iron box I have taken. You can check the different iron box, the design is totally different because each company has protected with the design. Design it should look beautiful to eyes, not mere functional or technical feature of the article or not culture design. How it looks, that it's a beautiful cup set, beautiful sofa set, beautiful chair. The Ketan fan is different from Bajaj fan. HP printer is different from some other printers though, because all the designs have been registered. Term is 10 years. You can extend for 5 years. Again, total 15 years term you can enjoy if you are developing some new designs in the market. Sanitizer machine design. Earlier we are not knowing when the COVID came, we came to know this also having one machine which we can use for sanitizing. This also machine has been registered design. We can check different examples like ampoules, capsules, thermometers, bottles, syringes. All the designs are registered and they have got benefit out of that. So if you are also developing any design which is not in the market, if it is new, then go for the registration. Again, you can check textiles and jewelry designs, curtain designs, sari designs, dress designs, jewelry designs of different kind, watch designs. You can check different watch design. Timex, Titan is different companies having different designs. So whatever design which is not in the public domain, that's a new. We want only novelty in the design, something which look different from the design which is already in the public domain. Again, you can check the shape, configuration, surface pattern of bottles. All these bottles are registered designs. See how they are look differently. You cannot say this is different design from this design. It's also different. Therefore, it acknowledges the novelty of that design. Therefore, these designs all are registered. Again, design of toy, school bus, bat, clock, pen, biscuit, pencil, all the designs are different. We know the pencil, but the pencil is having shape of peacock and parrot. Is something look different because what is not there in the popular design with these eyes of tigers colors, this is different. Therefore, all the designs are registered. This sharpener is we are already having, but combining with two sharpeners, the design is different. So all this got registered. Let us see another kind of intellectual property called trademark or brand name. Visual symbol, which may be word, name, brand, numerical or combination of colors to indicate the source of the good, to distinguish from the goods of the others. It gives authenticity of the goods like Amazon, Good Day, Pierce, Reliance, advertises goods and services, protect the innocent public from buying the goods of second-rate quality. We know many products are having different names. For example, Adidas shoes and t-shirt. In the market, if you go to the malls, you'll get in 4,000 so more than that. But in Mumbai side, you can get even in 200 because they change the spelling of that and mark of that and the same Adidas. Pond's powder, P-O-N-D spelling, but they use P-O-N-D with the same design and color. We never check what spelling is registered. We buy, that's a second-rate quality product. Therefore, you should know what the mark exactly means. Realize fresh, Puba, what you should know. Then you will not be cheated by the public. R with encircle is a registered trademark. TM is trademark applied, yet to get the registration because once you are applying, examination, opposition if any, then hearing, then you will get the registration mark. Therefore, you might have seen many bottles, many products, some are written R with encircle, some are simply written TM. Duration is 10 years. You can extend every 10 years by paying the renewal until it's used. Like I say something, how long in the company, Tata, Bata, how long they are in the market. They are renewing every 10 years their name. There are different marks like service marks, trade names, collective marks, certification marks, taglines, slogans, such like this in McDonald's, Coca-Cola, Google, this and again Adidas, again Naukri.com, Edil Mange More, Bureau of Indian Standards. So all these are registered on different marks. Let us see another kind of intellectual property called geographical indications. Place names used to identify source of origin, quality, reputation, or other characteristic of products like Darjeeling tea, Kanchipuram silk sari, Kolhapuri chappal, Agra peda, Nagpur oranges. Term of protection is 10 years. It can be renewed every 10 years of the usage. If you are filing patents, designs, trademarks, any person combining with professor, student, MSME, startup, or anyone can file the patent application. But in GI, a group of people who involved in the particular business are having the association in group, they are supposed to file the GI. Is an Darjeeling tea GI. Makrana marble from Rajasthan. Patlami Sev, Kanchipuram silk sari. Katputli of Rajasthan, Bag printers of Madhya Pradesh, Bengal Patachitra, Chireli paintings, Bidri ware, Worli paintings, Maghai pan, Devanhalli pomelo, Apimedi mango, Kashmiri saffron, Sahilicha of Bihar, Coorg oranges. So all this got GA for that. Let us see another kind of intellectual property called copyright. Provides holder the right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, software. The term of protection is life of the author 60. Therefore, you might have seen many singers sung the song, they are no more, but still they are getting the royalty. Many authors written the book, still they are getting the royalty for that. Literary works means the books which you write, autobiography, story, novels that you can come under the artistics, like which arts you develop, that's art. Dramatic, any dramatic works, musical works, sound recording, cinematographic works also comes under the copyright. Now, how we can protect a single product with a different intellectual property? For example, in the year 2000 or in and around that, Sony TV was very famous for clarity and sound, especially with the two hoopers on the top of that, which gives the sound like a loudspeaker. Therefore, the remote control mechanism is a technology, they got patent for that. How it looks with a different color combination, beautiful. So they got the design registration. Sony name as such, they got the trademark. The instruction which are there in the box of TV is in copyright. So single product is protected by more than one intellectual property. Therefore, other company will not copy neither patent, nor design, nor trademark, nor copyright. Therefore, they can plainly play in the market and earn a profit out of the market. Therefore, another company who involved in the manufacture of TV like Samsung has not copied any one of these. If they copy, Sony will sue them in the court and they claim the damages for that. Therefore, every company is protecting their technology like Nokia, Sony, Samsung, Vivo all got their production with different intellectual property rights. Let us see what is trade secret. Trade secret means something which is not disclosed to others, kept or maintained secretly years and years together. I have taken pizza as an example to make you understand clearly. You might have tasted the Domino's pizza and the pizza which you get in other hotels. The taste of both is different because they're adding some trade secret ingredients which are not known to us. They enhance the taste of pizza and they are disclosed to the people who work in the kitchen of Domino's with the non-disclosure agreement with those people. Therefore, they never been disclosed. Many examples are there of trade secrets. They are kept. The formula of Coca-Cola, we don't know. The formula of Mazda, we don't know, because they're adding some trade secret which are not known to us, and they maintain secretly because they want to play in the market and they catch the market. Here showing you that Nokia different design, mobile you can check, Vivo mobile you can check, Reliance you can check, all the designs different, and they got their name registration with their company. The combination of hardware and software, they got patent for that. And how it looks beautifully with different, all the designs have been registered. So single product, each company product with different type, and therefore Nokia will not copy the technology of Samsung, Samsung will not copy the technology of Sony, will not copy the technology of Vivo or Reliance. Each independently they can play in the market. Therefore, if you are also developing any technology, first protect with the possible IPs, then come in the market so that no one will copy. Plainly, you can play in the market, you can earn a profit out of that IP. This is for the students. What can do with the IPR? Why government is making to know about the IPR? Why they are making one of the subject for the B, MTech or PG students? What is IPR? If you are a science graduate, you can become a patent agent every year. Our office calls for the patent agent examination. If you qualify, you will get a patent agent number from our office. You can work in anywhere else in the patent field or IPR field. If you are a humanity graduate or science plain graduate, or if you are a lawyer, then you can become a trademark agent or copyright agent. If you're having knowledge of IPR, you can work in the IPR policy of or IPR cell of central government, state government, colleges and universities. Or you can work in the NGOs who are becoming facilitator between inventor to the government of India. Or there are different IPR firms in the cities. You can join with the IPR firms who are helping to file patent and prosecute them until the grant of it. If you're any branch of B or MS in chemistry, biotechnology, microbiology, physics, you can join to the government office whenever the ad comes, depend upon the subject of the institute. Again, there is two papers. One is objective and the descriptive. If you qualify, you'll get job in the government office. You can do what thousands of scientists, faculties, students can also be inventor, but they are not doing. How they can be an inventor? By simple approach. While carry to research during your PG or MPhil, PhD, or doing your project for getting the degree, identify some problem in your field. Solve that problem, you can apply for the patent. I'll give the example. If I'm a microbiologist, then I can give solution. Now we are treating pond and river water by chemical method. So I can give a herbal treatment of pond water so that it will not affect the aquatic life of animals. If I am a biotechnology person, the process of production of biodiesel from my campus waste plants, production of methane from my campus waste. If I am electronics and telecommunication, a device which can give alert or SMS alert to the farmer when the wild animals entering his field, or a machine which can indicates that you are getting heart attack. So depend upon you, you can choose the topic. If you are a mechanical engineer, a device which converts solar energy into electrical energy, a device which converts air energy to or wind energy into electrical energy. So you can solve that. A vehicle which run on hydrogen fuel. Anything you can give, that is a solution for this, and you can apply for the patent. You will get a patent for that. If you are a medicinal chemistry fellow, then a herbal composition for curing the dandruff. Because Vatica is there, Doe shampoo is there, Sunsilic shampoo is there. You can give the herbal shampoo by taking from the medicinal plants. Or a lotion or a medicinal composition for treating psoriasis. Because you know the medicinal plant, and India is very rich in the medicinal plants. Or you can give any type of the process of isolation, some useful compound from medicinal plants. So depend upon your subject, you can think a simple subject, solve that problem, definitely you can apply for the patent. What can be patented in India? All processes and products which are new, having inventive step and capable of industrial applications are patentable in India, which are not patentable are Section 3 and method of treatment, plant as such, animal as such, pluralist inventions, method of presentation, flow diagram, all these are not patentable in India. And as per the atomic energy related elements also not patentable. But product codes, apparatus, devices, machines, chemical products are patentable in India. Every country is having different law, what to protect, what not. When we can say your technology or your invention is new. When it should not be published in India or elsewhere. When it should not be in the prior public knowledge or prior public use within India, or claimed before in any specification in India or elsewhere, then you can say that your technology is new and then go for the patent filing. When we can say that you are fulfilling the requirement of invention. Feature of invention that involves technical advancement as compared to the existing knowledge or having economic significance or both, then we can see. For example, earlier I shown you one example of telephone. Now mobile. What is this? Technical advancement. Therefore, Nokia and Samsung got patent. Economic, earlier when the mobile came in the year 2000, so very costly. Now 1,500 up to 40,000 we are having. That's an economic significance because of improved technology. And that make invention not obvious to a person's skill. What is not obvious to a person's skill? Means if you are a chemist and if somebody is preparing the process of production of an biodiesel from so and so plants, then you are being a researcher in the same field. It should not leak to you. It's a very obvious process. Anyone can do that. For example, one of the document in literature survey has disclosed with the while making a process of making tea, one of the fellow like Karnataka fellow has using the elaichi, that is for the tea. From Maharashtra, the people are using some roots of tea for making tea, some roots of medicinal plants. Gujarati fellows are using ginger for the tea. These three are disclosed in public domain, but somebody is from Andhra making the combination of these two making the tea. It's very obvious to him. It's very easy to him. So to do a patent, to fulfill the requirement, it should not be obvious to him to fulfill the requirement of this. You should have a surprise result, or if you are giving solution to a long-standing problem, or if you are solving the full field of a long field tree, or if you are doing great technical process, then you are fulfilling the requirement of invention. Again, it should be made or used in the industry. So one of the example is we know the Parkinson's disease. Again, we know that we are having a allopathic treatment of that, but one of the scientists want to give a herbal formulation for the treatment of Parkinson's disease. It's an alternative method. Why he is giving? Because synthetic drugs are costly. They are having side effects like gastrointestinal, like nausea, anorexia, orthostatic, weight gain, psychiatric symptoms. Therefore, he want to give an herbal solution for that. So his main objective is to provide the plant-based solution, which is having no side effects. It can be used as tonic. It is readily soluble. Therefore, he is giving this solution. So if you are giving any alternate solution, it can. And he is selecting one of the medicinal plant of their parts and mixing with something else with the 80 to 90%, stabilizers, untouched using, and he's making the Ayurvedic formulation. So this is the way and giving the solution for a process of preparing plant-based Ayurvedic formulation for treatment of Parkinson's disease. His inventions lies in the medicinal plant with the so and so percentages. So it's a way of writing the subject matter for doing the invention. So this is the exact what content of his medicine or his syrup. Lastly, sign up the applicant is required. If you are doing new compound or if you are isolating new compound from anywhere else or producing new compound, a compound of Formula 1 having so and so. This is a Pfizer product application. If you are writing process, if you are doing something, the process of preparation of a benzapril. So you have to discuss with what it is reacting, how we are getting production, Ranbaxy application. If you are doing composition discipline, a pharmaceutical composition having azilistine and salt thereof. Claiming compound plus salt thereof for nasal or ocular administration. Again, he is telling it may be in the form of suspension or solution. Again, he is telling it may be eye drop, nasal means he is claiming all the possible form of that product so that its competitor will not copy any one of the form of this drug. So this is the way of writing the claims and examples of the patent application. Now we came to know what is patent, what is design, trademark, copyright. Now let us see how to file the patent application and where to file. Any individual, natural, foreigner, company, MSME can file the patent application as per Section 6 of the Indian Patent Act. You can physically visit to the office, you can file, or we have given the facilities online since July 20. Sitting in your office, you can file the patent application. There are different jurisdictions as you are from South, so Chennai is your jurisdiction. It covers state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and the unities of Pondicherry and Lakshadweep and newly formed state Telangana. Minimum documents required are Form 1, which indicates the applicant details, and in that Form 9, column 9 is to proof of right to say whether you are signed the application or not. If you are filing the complete or provisional, Form 2 is must. Provisional means as soon as idea comes to your mind, you are writing on some papers and you are filing the patent. If you are filing your Form 3, that is whether you are filing in foreign countries, which countries you have filed, what is status, you have to mention every 6 months. Therefore, Form 3 is must. Form 5 is for the declaration of inventorship. As in the paper publication, we add our friends' names so directly or indirectly helping us to carry out the research. Same in Form 5 is for addition of those names. But in patent, all the inventors are having equal right, not like the paper, first other second. Form 18 is a must for the request for examination. If you request, then only we examine the case, otherwise we will not examine the case. These are the optional requirements, Form 9, Form 26. Fees for online filing is 1,600 for the natural person, 8,000 for the others. Again, for the form filing 18, 4,000 for natural person, 20,000 for the other than that. Form 9 is an optional. If you want, you can file for early request for a publication. If you want to get a early patent, that is called expedite examination as per Rule 24B. For that, Form 18 is required. Who is eligible for that? While if you are choosing or filing a PCT application and choosing India as an international searching authority or international preliminary exemption authority, or applicant is a startup, or as per 2019 rule, one of the applicant can be ladies or government organization or institute can file the Form 18A as per Rule 24B. Fees 8,000 for individual, 60,000 for the company. If you want to file the forms, if you want to get the forms, you can go to www.ipindia.gov.in. If you want online filing, you can go to ipindiaonline.gov.in. Digital signature or e-signature is a must for online filing. Once you are filing the patent application, it's go for the digitization. We screen and classify depend on the subject matter like chemistry, mechanical, electrical, electronics. Depend upon that, we use the International Patent Classification System. If you are requesting for early publication, we publish within a week or a month. Otherwise, it takes 18-month publication. Once it published, any person can file the pre-grant application by representation. If you are requesting for examination within 48 months from the date of filing, then your application will go for the allotment of to the exam. Once it's allotted in the respective groups like mechanical, electrical, biotechnology, and microbiology, then it has to allot to the examiner and controller. Then examiner will start the doing formal technical observation to carry on the search whether it is novel or not. He prepare the gist of observation forward to the controller. Controller again check overall. He can amend, delete the observation and make the final gist of observation forward to the applicant, or if he is filing through agent, applicant agent. That is called first examination report, FER. Once you got the FER, within 6 months, you are supposed to file the reply by that on each ground. If you are unable to file the reply, you can file the extension by requesting on Form 4 3-month extension with the paying more fees. Then within 9 months, by hook or crook, you have to file the reply for the first examination report. Once you file the reply for that, if it is persuasive, okay, it will be granted. Otherwise, it will be rejected. If it is granted, within 1 year from the date of grant publication, any interested person can file the opposition. Now, who is the interested person? For example, Bharat Serum Institute of Pune is doing some research in the field of pharma, and he got the patent. Then Biocon of Bangalore or Bharat Biotech of Hyderabad can file the opposition because they involved in the manufacture of a similar pharma product. Therefore, they are called as person interested within 1 year from the date of publication. Once you file the opposition, the ground of oppositions are forwarded to the applicant. Applicant has to reply each ground clearly, sufficiently. The reply which is issued from the applicant will again forward to the opponent. Opponent again reply for that letter. If applicant or opponent requests for a hearing, we conduct the hearing. Simultaneously, we constitute an opposition board inside the office. There are 3 officers, one is chairman, 2 are the member of that opposition board. They give the recommendation of the opposition board, whether grant or refuse. During the hearing, applicant, opponent, and controller, examiner, with the help of opposition board recommendation and the reply filed by the applicant, they discuss the each ground clearly with the opponent and applicant. If applicant overcomes all the ground of the opponent, then it will be granted. If he fails to overcome the grounds of opposition, it will be rejected. If you are granting or rejecting, we give the speaking orders so that they can challenge our orders in the high courts. Once it is granted, same day we issue the certificate of grant. What is the role of intellectual property system? Encouragement for improvement of the technology, providing reward as an exclusive right for disclosure, making profit or earning royalty through putting the invention to practice, not for the namesake, keeping a record. Transferring to public property after expiry of term, means of 20 years, or if you are unable to pay the renewal fees, it will be seized, then anyone can use your patent application. What to do now? We came to know different form of intellectual property, their importance, how to write and how to file applications. Don't wait now. Save the benefit of patent system, school, colleges, universities, public, anywhere you will get an opportunity to share the knowledge and share the benefit of patent system. Utilize the resource through organized R&D activities. Capture the global market like Samsung, Sony has how they have got judicially, earn profit through the protected market so that other will not copy your invention. Thank you. You can ask any questions now.
Yes, sir. Thank you, sir, for making this even more informative. Dear participants, if you have any queries, kindly put it in the chat box. I'll also check out on YouTube, sir.
Okay, you can check, ma'am. You can check. Any doubts, you can talk to me.
It seems a very clear session, sir. No doubts in the chat box and also in YouTube.
Thank you. Thank you, ma'am. Thank you.
Yes, sir. Thank you, sir, for making this even more informative. It will help us in huge way. Thank you so much, sir.
Thank you, ma'am. So, how many participants approximately, ma'am?
I think more than 150, 200, sir. I need to check out the YouTube link live also. So, based on the feedback link, I'll just notify you, sir.
Okay, because today by I have to put the report only number. You can send later afterwards, but just tell me appropriate number. Okay,
Yes, sir. Yes, sir. Coordinator will coordinate with you, sir. Ms. Tamashudan, ma'am.
Thank you, ma'am. Thank you.
Yes,
Can
sir.
proceed. Okay.
Thank you, sir. Thank you so much, sir. Dear participant, I have given the feedback link in the chat box. Kindly fill the feedback link. Thank you so much, sir. Feel free to leave the session, sir. Dear participants, please fill the feedback link to get your certificates. Feedback link I have given in the chat box. And people, those who are watching YouTube live, kindly check the live chat. I have given the feedback link in the live chat.